Well, welcome, welcome, welcome. We are going to go ahead and at least get started slightly early. We're not going to start the presentation probably until about 12:01 because people always, for those of you who have attended our webinars before, people always have technical problems, sound problems, whatever, and usually it takes a few minutes to get those things worked out. So we try to start this all a few minutes early for the new folks to make sure everything is working. I am not Rochelle Gretchen or Lori McFalls. They will be joining us in a few moments. My name is Michael Horton. I'm the Director of Advocacy at Legal Services Alabama, and we're really happy to have this chance to share information on the current COVID-19 crisis. I don't know if happy is exactly the right word, but or at least we're doing the best we can to do what we can. So before we get going, and we will start shortly again. Just a little bit about Legal Services Alabama. Legal Services Alabama is the only statewide nonprofit law firm providing legal services to the poor. We are operating in all 67 counties in Alabama. We have 8 offices, including a virtual office in Anniston. I hear someone's phone call in the background. Legal Services does help about 11,000 people every year, but there are about 1 million people living in poverty in Alabama, and about 1.5 million or 1.7 million who qualify for legal services. So we obviously can't do everything. That is why we always appreciate the hard work of pro bono lawyers around the state. And we always take this opportunity to ask everybody who's a lawyer who's watching. If you don't currently volunteer, you can either contact your local volunteer lawyer program if you know who that is, and if you don't, you can go to the State Bar's website and sign up, and they will direct you to the correct volunteer lawyer program. Combined, we help about 17,000 people every year. But again, that's basically out of 1 million people who need help. There's a real gap there, and you know. While it'll be difficult to ever truly fill it, the best we're going to do is together, pro bono attorneys and legal services working together to do that. I did want to, we've been asked by the Alabama Law Foundation to make a special announcement today in light of the COVID-19 crisis. Alabama recently joined many other states around the country offering free legal answers, which is sponsored by the American Bar Association. And so Tracy Daniel at the Alabama Law Foundation asked us to share if lawyers would be interested, and this would basically be if you were going to get someone to go to free legal answers, they'll fill a question out. It'll be a low-income person. They will then send the question to you at your home, and then you'll be able to respond at your leisure. So that would be another great opportunity to volunteer, and at your own pace. And really, the nice thing about that is you can volunteer from anywhere in the state, and help people all over. Obviously, several counties, Madison County, Mobile County, Jefferson County, have a lot more attorneys than some of the other ones where they have less than 10 practicing attorneys. And they really need help in providing that service. And if you want to go to that website, it is alabama.freelegalanswers.org. And if you didn't get that at the beginning, we will put that up on our website and our Facebook page as well. Legal Services Alabama will be showing that shortly. Couple of things before we get going with the webinar, because I always get these questions. If you have registered and you gave us your Alabama State Bar number at the very beginning when you filled the registration form out, as long as you click and attend the entire training, there's nothing else to do. We will turn in your forms to the bar. You will get credit. It should show up in a couple of weeks, depending on, I don't actually know what the State Bar is doing in terms of staying open, but there's nothing else to do. As long as you registered and you stay through, you will get credit. If you leave, and really the State Bar doesn't tell us 100% what the cutoff is, but the system does know if you stay on. If you leave, it'll know that you turn the program off, that you're not watching, And so you wouldn't then necessarily get credit if you just leave at 12:05. So just be aware of that. I don't think most people do that, but occasionally we get somebody who signs on for 1 minute and thinks they're going to get credit, and they don't. As far as what we're going to do today, there's a chat feature on the side of your bar. You will not be able to talk to the presenters, but if you have questions, you can type them over there, and I will pass along your questions to the presenters as time becomes available. What I usually do is I don't necessarily ask them immediately, but as soon as they take a break, we jump in there with questions. Some of this stuff they may very well not have answers to. You can see the note on the thing says the state of this law as of 3/20/2020. But even as we were getting this all set up 10-15 minutes ago, we were getting new emails with different things changing all over. So it should have said as of 11 o'clock on 3/20/2020. But so they might not have answers, but to the extent they do have answers, over on the right-hand side, the chat button, that is where you enter that information. And I will do the best. That is also the best place to put it if you have audio or visual problems, and we will work on that as well. So there's a chat function. Once again, my name is Michael Fort. I'm the director of Legal Services Alabama. We're very happy to be here to present this today. And check the time. We will give them probably 1 more minute just so people signing on, I can still see attendees showing up as we're sitting here. We're all glad you're all here. And again, if you are looking for bar credit, there's nothing else to do. If you signed up, you registered to attend, you'll get the credit. It'll know who you are. And if you have questions, just type them in the chat and I will get to it. Well, I think it's about 2 minutes after, so hopefully everyone who's here, it's number's still going up, but hopefully everyone who is here who is supposed to be here, and we are going to get started. So without further ado, I'm going to turn it over to Ms. Laurie McFalls and Rochelle Gretchen and let them introduce themselves and get going. 1 second with the and like some of you, we are also dealing with children who are out of school. God bless them. God bless them all. Now, without further ado, Laurie and Michelle.
Hi, everyone. My name is Laurie McFalls. I'm a staff attorney with Legal Services here in the Huntsville office. I'm also the state lead for education. Rochelle, you want to introduce yourself?
Sure. And my name is Rochelle Gretchen. I'm a staff attorney in the Dothan office, and I head up our empowerment group, which deals with a lot of public benefits like food stamps and Social Security and unemployment cases. So that we wanted to, we kind of put our heads together to try to think of issues that our clients are facing right now, and also issues that have already come in to us. And this is by no means an inclusive list of things that we have identified, but we just kind of wanted to do a broad brush overview of some issues that we've identified so far, and also wanted to open it up to see if people have had issues that have come up. And like Michael said, this is as of today, but it's really as of this morning because things are constantly changing hour by hour. And so here are some of the topics that we're going to be discussing, and Laurie will kick us off with evictions.
And as Mike said, this is, I hate to keep hearing this phrase, and I apologize in advance for using it, but this is a rapidly changing situation. So the information that we're giving you today is current as of about an hour ago, and some of it is new information, and we just don't have a lot of information on that. So we'll be giving you updates, but we won't have a lot to the updates because we don't know. But we are going to get started with evictions. Obviously, evictions happen all the time. Normally what the process looks like is a landlord has to provide a tenant with a notice telling them that they have 7 business days to cure the breach or leave the property. This is in most cases. There are some offenses that you don't have to provide a right to cure, but we're not going to talk about those today. We'll follow up in a later webinar about all of that. But assuming, for example, that you're being evicted for failing to pay your rent, your landlord must give you a notice that says you have 7 business days to pay the rent, and they have to specify how much rent is owed, and then they do have to accept it within that time. If the 7 business days go by and the tenant fails to make the cure, then the landlord can file an unlawful detainer complaint with the court. At that point, the tenant will be served, and the tenant has 7 days to file an answer, not business days, just 7 straight calendar days. If a tenant, and then the eviction has to be set out at least 14 days. Then assuming that a tenant goes in and loses for failure to pay, then the landlord can obtain a writ of possession from the court after 7 days. And then the sheriff will come out and help the landlord in setting out the tenant's belongings. However, right now, because courts across the state are closed, this process is not happening exactly like it's supposed to. As a result of that, you've got tenants across the state that are not able to file answers, tenants across the state that are able to file answers, but only if they mail them in or if they put them in a drop box outside the courthouse. It's important to know what's going on at your courthouse and what rules your clerk's office is following, and to advise tenants as to what they need to do. Obviously, the safest thing for them to do is to file an answer by mailing it in. Or, of course, if you're filing, you could continue to do so electronically. We do anticipate there being a mass number of motions to set aside defaults after all this is over, because the timing is just going to be really wonky unless we get further guidance from the Supreme Court or AOC. So again, you got to keep up with what's going on in your area so that you'll know when their answer would have been due under the laws of civil procedure, given that the courthouse was closed for a period of days during that time. What we do anticipate happening, and we've already seen an increase in this around the state, is landlords getting frustrated that they can't file evictions, or that even if they file them, that nothing is going to happen for quite some time. Because of that, landlords are engaging in what's called a self-help eviction or a lockout. You can see the statute here pertaining to lockouts, and basically, like, it includes things like your traditional lockout, where a landlord changes the locks or removes the tenant's stuff from the property. But another thing that people don't always realize is that if the landlord turns off your power, shuts off your water, things like that, that's also considered a lockout or a self-help eviction under the statute. And the reason for that is because then you're constructively evicting them. If they don't have power, then they're going to have to go somewhere else. There's a couple different things that you can do if somebody approaches you and their landlord has told them that they're going to set them out. The first thing is if the tenant knows in advance, you know, my landlord says they're going to change my locks, the easiest thing to do is just call the landlord. Most of the time, but not all, landlords respond well when an attorney calls and says, hey, if you do this, you're going to have to pay the tenant 3 times the monthly rent, regardless of the fact that they didn't pay you. And it's one of the few times in the Landlord-Tenant Act when the tenant can actually get attorney's fees. So not only are you going to be paying 3 times the monthly rent, you're going to have to return the security deposit under the statute, and you're going to be paying my fees as well. Generally speaking, landlords at that point will not carry through. But if they do, then you'll have to file for an emergency injunction. It should be noted that this is one of the few exceptions under the Supreme Court's administrative order that you can file now and that you will have a hearing on now. So that's always an option for you. And the other thing is, I'm sure that you've heard all the headlines, you know, Trump says there's going to be a moratorium on evictions and nobody's getting evicted, and this is creating mass chaos in the landlord-tenant world, and it's also just not true. Rochelle's going to talk about that a little bit more here in a second, but it is important to note, if you're getting calls, that tenants do still have to pay rent at this time. Although some states have issued moratoriums on evictions, Alabama is not one of them at this time.
Thank you, Lori. And, you know, I've seen some news articles earlier this week from The Hill saying that, you know, there is a moratorium on evictions, but the guidance that has come out is really relating to a couple of loan foreclosures. So there is, for a certain loan servicers, there is a moratorium on foreclosures, and the press releases say evictions, but here in Alabama, when we use the term eviction, we're talking about landlord-tenant, and when we're having an ejectment for a homeowner, after foreclosure, the terminology we're using is ejectment. So I think that might be causing some of the confusion here in Alabama. So far, as this morning when we last checked, we haven't seen anything stopping evictions in Alabama. And you can go to the next slide. But we do anticipate people having issues paying their mortgage. COVID-19, people being laid off of work or not able to earn the income that they were planning on or used to earning, we do anticipate there being people who have trouble making their mortgage payments. And we can kind of make an analogy to natural disasters. After a natural disaster situation, sometimes FEMA might come in, or there might be some sort of grant or loan available. And mortgage companies often, after a natural disaster, will offer different forbearance or loan modification options. Although this is not a FEMA natural disaster situation now, we can kind of use some of the tools that we do after natural disasters and carry it over to this situation. So for an attorney, the best thing to do is to gather the information on what's available, help clients determine what their best option is, and if there is some sort of application they can file to help with those, and to help if there's an appeal if needed. And you can go to the next slide. So as far as gathering information, the client really needs to know who is the mortgage servicer and who owns their loan. A lot of times that's not the same entity. Sometimes it is, but not always. And once you know who owns the loan, you can find out if there's any program or assistance available. And some of the things that are available, and again, some of these are available throughout just in your normal everyday time. And then some mortgage companies will do additional, relief after a disaster. So some of the relief that could be available would be a forbearance, where the mortgage company either allows you to pay a lower payment or suspends payments for a period of time. You ultimately would have to make up those payments later. They might be put on the end of the loan, or it might be some sort of payment plan at a future date, but you can get some relief for the present situation. You can also apply for loan modifications, where you're trying to reduce your payment, maybe reducing your interest rate, or increasing the number of years on your loan. And then finally, there's some options if you decide you don't want to keep your home, maybe a deed in lieu of foreclosure or a short sale. Usually when clients come to us, they're not wanting to think about those other options. They're wanting to think about forbearance or loan modification options. They're wanting to keep their home. And I put the number for the HUD approved housing counselors. Anytime someone is looking at doing a loan modification or entering into one of these plans, it's a good idea to get some advice, either an attorney or a housing counselor, so you can go through and see if it makes sense for you. Legal Services has a couple of HUD certified housing counselors on staff who can help with that as well. And you can go to the next slide. As of last night when we were putting this together, there were 3 government-backed loan servicers that were offering COVID-19 specific relief. And it's important to find out who owns the loan and go to each of those places. There's also some private mortgage companies that have indicated they're going to be offering relief as well. We put the links to the Fannie Mae, Freddie Mac, and FHA mortgage press releases. And kind of going back again, the confusion on the suspension of evictions, I believe, came from that FHA, the announcement about suspension of evictions. It's really a suspension of people who are, who have a mortgage with one of these companies. They're suspending foreclosures and ejectments for 60 days. And you can go to the next slide. So under each of those 3 programs, so what they're saying now is that they're suspending everything for 60 days. Homeowners affected are eligible for a forbearance plan to reduce the payments for up to 12 months. And we would encourage people to reach out now and not reach out later. A lot of times clients might think they'll be able to catch things up, but things can end up snowballing, and it's better to reach out sooner. Once a mortgage goes to a foreclosure attorney, there might be additional fees, and it might be harder to roll it back. And with these forbearance programs, if you are entered into one of those, they're not supposed to report to the credit bureaus that you're late on your payments, and they're not supposed to charge late fees. So that can also help a client protect their credit report and their credit scores if they get enrolled in one of these programs. But the best, plan is just to find out who the mortgage company is and what programs they are offering. And when I last checked, I didn't see anything for VA or USDA specific to COVID-19. They have general hardship programs in general. And again, stuff is changing. There might be something coming out on any of these mortgage companies.
And to that end, as people are going through this crisis, they're not able to pay their bills. We suspect that people are going to end up, there's going to be a lot more collections type lawsuits. And as a result of that, there's going to be a lot more garnishments. The other more immediate problem that we're having is people that already had prior judgments and weren't able to pay on them. Their wages are being garnished now, or the garnishment perhaps went out right before all the courthouses started closing. There's two different types of garnishments that you need to know about. There are bank account garnishments, which is a one-time garnishment, and then there are wage garnishments, which is a continuing garnishment. With a wage garnishment under federal law, 25% of your paycheck is being garnished at any for each paycheck until you've paid off the entire judgment. The tool to stop both of these types of garnishments is a claim of exemptions. Now, when you file a claim of exemptions, you can protect for a bank account up to $7,750. With a wage garnishment, you can protect $1,000 per paycheck. It does not matter how often you're paid. Obviously, people who get paid once a week will be better off than those who get paid once a month, but it is $1,000 per paycheck. One thing that's interesting about claims of exemption is that historically in the state of Alabama, more pro se litigants file claims of exemption than attorneys file claims of exemption. Again, with the courthouses being closed, people are not able to get to the clerk's office to file a claim of exemptions. This means that anyone who's been served with one is going to be calling every lawyer they know asking what to do. And the answer is it's a fairly simple tool if you have the form. And we're happy to send that out. If you have questions, if you need us to send it to you, we can. Back in 2015, the Alabama legislature enacted 610.6.1, which says that wages do not count as personal property for the purpose of wage garnishments. As recently as January, the Court of Civil Appeals gave guidance of that through Renters Realty versus Smith, and they determined that that law was in fact unconstitutional. At this point, Renters Realty has filed for writ with the Supreme Court, but that has not been granted. This means that Renters Realty is good law, and we've not heard of any issues with judges around the state not following this law at this point. So if you end up in a situation where you filed a claim of exemptions and the plaintiff files an objection and says, no, 610.6.1, you do have this case that you can fall back on at this time.
Okay. We wanted to talk briefly about consumer issues that we're seeing with our clients, also with our family and friends as well. And we wanted to talk about price gouging, phony cures, and internet scams. Unfortunately, during stressful times, we see an uptick in some of this predatory behavior, and we're seeing that now. I think people might be stressed out for everything that's going on and maybe more vulnerable to some of these than they might otherwise be. Yesterday, Attorney General Steve Marshall issued a press release reminding people that the price gouging law is in effect, and it was activated March 13th when Governor Kay Ivey issued a public health emergency. So what is price gouging? Is if someone is raising the prices of commodities by more than 25% during a declared state of emergency. And so to avoid that, you can kind of look at what the average price is and see if it's been raised too high. The exception is if the wholesaler has raised prices, retailers can pass that on. But if you're taking advantage of the run on toilet paper or hand sanitizer by raising prices, you could be subject to a fine of $1,000 per incident, or continued or willful violations could cause someone to be banned from doing business. And to report price gouging, the Attorney General's office has an online complaint, or you can call. I think most places are recommending people do things online before they try calling. And so next, we've also seen a lot of fake cures going around. People are saying there might be a cure for the coronavirus, like a vaccine or an essential oil or a tea. And there's been emails from the CDC and World Health Organization. And you can go to the next slide. And some of these are, just scammy in general, but some are also trying to kind of get your personal information online to do further damage. And we do recommend at any time someone can go and put a freeze on their credit. They can go to each of the credit bureaus and put a freeze on it if they're worried about someone taking advantage of their personal information and doing damage with that. We've also seen phone scams, and I wanted to highlight this. The Social Security Administration is closing their in-person offices. And they are recommending people do business with the Social Security Administration by phone or through their website. And generally, the Social Security Administration is not going to call you, and the IRS is not going to call you. They're not going to ask you for your information. They're not going to ask you to pay money. They're not going to do any of those things. But the Social Security Administration did put up on their website that if anyone has had a scheduled appointment with them, they will be contacting you by phone to reschedule. It's important to note that they're not going to be contacting you to ask you for information, and they're not going to be contacting you out of the blue. You would know if you had a scheduled appointment that you need to reschedule. And the best, advice, if someone's worried, they can just hang up the phone and then look up that number independently and call it back on their own. Also, there's a lot of talk about $1,000, that the government's going to be sending everybody $1,000, and that legislation has not come through. It's not been, it's not passed. What has passed, we will have a webinar next week, is the Family First Coronavirus Act, and that particular legislation does not include a provision for everyone getting, checks from the government. But we have seen scams already coming down. For people saying, in order to get your money, you need to provide information. And so it's important for people to know that has not come through yet. And if it does come through, they don't need to be talking to someone over the phone or over the internet to give up their personal information. And, a couple other things. There's been Alabama Power saying people are calling, pretending to be them, and online there's a lot of coupons going on saying, for example, I saw one this morning where Starbucks is saying, or quote unquote saying, that they're sorry for not being open. Here's a $100 Starbucks coupon. I think when people are stressed out, they might be wanting to believe that that's true, but if you get something like that, that's a scam. They're trying to get your information online or some other way. So just remind people that, these things that sound pie in the sky are most likely a scam, and it's just best not to click on those things because they'll try to get your information.
And before you go on, we did have one question. Someone wanted to know, in light of the Supreme Court's order, are eviction cases going on at this time?
The short answer is no, they shouldn't be. However, we have heard of some counties across the state who, although their courthouses are closed, they are allowing defendants to mail in answers. And if they do not mail in an answer within the 7 days, then they're issuing defaults. Obviously, that's illegal. It should not be happening. And if it does, then you're going to be looking at filing those temporary injunctions, which, again, those should be allowed. But we do have courthouses that are saying, look, you can file a complaint for an eviction if you want to, but we're not going to send it out. We're not going to do anything with it. And we're not going to enter any kind of defaults until a week after our court reopens, whatever that is. Again, it's really important to know when you're, what's going on with your courthouse, what your clerk's office is doing before you provide those answers to clients. So, I mean, the short answer is nobody should be getting set out right now on a new eviction. Complaints can be filed in evictions, but answers shouldn't be due when the courthouse is closed.
Well, and I would say a lot of courthouses are open. They're just not allowing people to come in person. So there's a lot of courthouses that are open and they have maybe a drop box at the front where you can go and file something, but it's still considered to be open. So it's important to know that, because if your courthouse is open and the clerk's office is open, then your answer deadlines arguably would be still due.
The hearings
so
can't happen.
County by county.
Right, and the eviction hearings can't happen right now. So I mean, if you were to get an answer back and the judge wanted to set it, it can't be set during this time under the Supreme Court order, because it's not one of those exceptions at this time. That may change any moment.
And we have a second question, which I don't know that Rochelle or Lori will know the answer to. And maybe if somebody else on the call knows the answer, someone's asked, does anyone know when Kate Ivey is going to make the necessary declaration directly to the Small Business Administration so that Small Business Administration emergency disaster relief loans will be available? So if you know, so much of what the governor's going to be doing is happening day by day. But if anyone else here does know, certainly just let me know and we can share it as we're going.
We're going to talk about school issues at this time, and I apologize. Mike referenced earlier that we've had received emails as we were preparing for this 10 minutes before we started. So I do have some updates that I want to go over. The first one, as you may have heard, Superintendent Mackey has pulled together a task force, and they're looking at, I know we all want to know when our kids are going back to school, and they do have a task force committed to figuring that out. And they are committed to graduation. So if you have a high school senior at home or you know of a high school senior, they have said graduation is going to happen. They just don't know when or what it's going to look like at this time. The task force has sent out questionnaires. They're looking to figure out how they're going to continue educating our children. They have several different options on the table, and they're polling schools to see which school systems are on the block system versus the semester system. Obviously, it makes a huge difference whether children have completed 50% versus 75% of their coursework in any given class. They do expect to be giving a recommendation to Governor Ivey by March 30th on what to do for the remainder of the school year with education. One thing they have announced today is that the White House has said that the Department of Education will not enforce standardized testing requirements for this year. So one of the things that was holding the committee up was trying to figure out how in the world we were going to do standardized testing. That's no longer an issue. One of the things that they're also looking at is how to handle students with disabilities. Obviously, if we have in place any sort of like e-learning, online classes, people are going to have trouble getting their IEPs met. The best thing I can tell you to do at this point, and the task force does know that this is an issue and they are looking at how to resolve that. So the best thing that you can tell clients is, number one, stay in contact with your school, stay in contact with the special education teacher. They are trying their very best to help in any way that they can. Some of them are able to put out, for example, I know here in Madison City, some of the schools have put out like the speech therapist has put out lessons online for all students so that people can continue getting some sort of speech exercises. So I would continue to encourage students to continue working with the schools and using their resources as you're able. And then number two, documenting what IEP resources you are still able to access versus those that you are not. If a child has a behavior intervention plan at school as part of their IEP, they should be trying to follow that same exact intervention plan at home and trying to stick as close to the IEP and homeschooling as possible. One of the problems that we're going to have if they come out and do online learning is that we are going to have a huge poverty gap when schools start back, whenever that may be. You're going to have kids whose parents are really on top of this whole e-learning thing. They have access to internet, they have access to computer, they're computer and internet savvy, so they know how to help their children work through the technology piece. And then you're going to have those whose parents are not able to help them with that. So we are going to have to take steps to narrow that poverty gap as we go along. Let's see. The other announcement that was made today is that the federal government has temporarily waived all interest on federally held student loans for 60 days, and payments are also suspended for 60 days. Again, this is only for federally held student loans at this time, and they have said that they're willing to go longer if needed. But right now, the mandate from today is 60 days. There's been a lot of questions about food security. And I'm not going to get terribly far into that right now because Rochelle's going to talk about it, but I do want to talk about the piece as it relates to school children. Alabama has received a waiver from the U.S. Department of Agriculture to continue serving lunches to students in schools, not school systems, but schools, where more than 50% of the students were deemed economically disadvantaged. According to a memo sent out to all the superintendents, schools can only serve meals if they utilize the summer food service program or the seamless summer option. There is an expedited application process for those school systems to go ahead and get their schools registered on those programs. They are taking steps to ensure that it's done in a safe manner. Among those steps are all sites that are giving out food must be operated in a non-congregating setting, and multiple meals can be distributed for multiple days. You see a lot of school systems that have their bus drivers driving their bus routes and dropping off meals, or they'll do drive-by pickups. The school systems or the schools that are not enrolled in these summer programs are going through food banks, or they're going through local churches or community agencies to work on getting these students fed. But because of the mandate with the 50% or more, you are seeing them go about it in very different ways. So you might hear of one school, and again, it can be different schools and within the same school system are going to have different rules, and this is why. So you may see one school that requires kids to provide their lunch PIN number, and then other schools that say if you show up with 5 kids, we're going to give 5 meals. And that's the reason for the discrepancy, is that they're having to come up with ways to adhere to these rules.
We did have one person who asked, he really needs an eviction now. He wants to kick out the roommate of an elderly person, and they were served by posting. Is there any way to speed it up?
Nope, there is not. One thing I will tell you is that you do not need to engage in a self-help eviction, or you'll end up being responsible for 3 times the monthly rent.
That was from Mr. Webb at Anston.
But you can, of course, with your attorney, file a complaint electronically, but it's not going to be sped up because the courts are closed and can't address it.
I would say, there is provisions for filing elder abuse protection orders. So I don't know what the situation is, but if someone's being abused in their home, there's certainly protections for protection orders or elder abuse protection orders that can be filed.
Sorry.
And so we wanted to talk some about SNAP, which is Supplemental Nutrition Assistance Program. It's also known as food stamps, and I tend to use those terms interchangeably. You may also hear clients talking about an EBT card, which is an electronic benefits transfer card, similar to a credit or debit card where the food stamp benefits are loaded onto each month. We do anticipate more people needing to file for SNAP benefits. In 2019, 15% of Alabama's population received some sort of food stamp benefit. And of the people receiving SNAP, almost 74% of those families had children. And the program by its name is intended to be a supplement for the food budget. It's not intended to provide benefits that would meet your entire food budget needs. But oftentimes I see families and clients who the amount that they spend on food each month equals the amount they receive from SNAP benefits. So it is an important resource for families. And the information that's on this slide is from the Center for Budget and Policy Priorities. And you can go to the next slide. So estimates are that each dollar in SNAP benefits generates 1.7 in economic activity. And right now there's over 4,000 retailers in Alabama who accept SNAP benefits. And right now, grocery stores are one of the few retailers that are open and doing business. So it is an important, not just for families for food assistance, but it's an important part of our economy. And you can go to the next slide. You can go to the next slide. There you go. So I want to talk a little bit about eligibility. Eligibility is based on income and your assets. And for income, DHR in Alabama is who administers the SNAP program. And for your income, they're looking at, is your gross income under 130% of the federal guidelines, and is your net income under 100% of the federal guidelines? And so that ranges based on how big your household is. And these are the eligibility limits for this year. There is some talk about maybe some additional SNAP loosening of the requirements, maybe some sort of disaster SNAP, they call it DSNAP, things coming down. So far, we haven't gotten anything for that. So these are you can go back to the chart. So those are the limits for that. Also, there's resource limits. DHR is looking to see if your household has $2,500 or less in liquid resources. They're not counting your car or your home, but they're looking at your liquid resources. And if your household has an elderly or disabled member, the liquid resources goes up to $3,500 per household. And if you have anyone who is curious if they could qualify or not, there's an eligibility checker online, and the link to that's on this slide. And again, if someone is struggling to buy food or to have food for their family, you can apply. I have a slide in a little bit with the online information on how you can apply online. I spoke with a DHR county supervisor here in the Wiregrass who said that they are still open and accepting applications. They are asking if people apply with a paper application that they put it in their Dropbox, and DHR will call them to continue that process. The good news here is that in Alabama, DHR has already been efficient in figuring out how to process applications online and on the phone. Many states require in-person interviews, and because DHR has already kind of gotten the infrastructure available to do things online and over the phone, they're able to quickly switch over, and they said they're still, processing applications.
We had a question. Do you know what the difference between net and gross is? Like what they take out of gross to get net?
Yeah, so they take out taxes, and they would look also at, they're looking at your, there's a formula where you kind of plug in your housing expenses and whether or not you pay for utilities, and they'll plug in that to see your net income. Net income is actually a little bit more forgiving. So if you're elderly or disabled, they'll only look at your net income limit, which seems like, it's a lower amount. So it seems like it's a hardship, but it's actually because they're taking into consideration your expenses, it's actually a more forgiving income limit than the gross income limit. And so for elderly and disabled people, DHR will only look at the net income. They'll take into consideration how much you're spending on, your rent or mortgage and your utilities to see what your net income is. And one of the things that did come through with the Families First Coronavirus Act is a suspension of some of the work requirements for food stamps, and that goes into effect April 1st. I see this being a really important benefit for our clients and for people who are being laid off or not able to work at this time. They don't have to worry about meeting food stamps work requirements. Without the suspension, food stamps requires adults who don't have any children or dependents to take care of. They have certain work, a certain amount of hours that they have to either be working or in some sort of program. And there's a 3-month time limit so basically if you are not working for 3 months in the 36-month period, you could be kicked off of the food stamp program. But the Act suspends those time limits. And so there could be people who maybe were previously unenrolled or no longer qualified for food stamps might be eligible now, or people who are working, maybe lost a job or got laid off. They don't have to worry about losing their food stamp benefits at this point. There's some other food related highlights from the Act. Again, next Friday, there'll be a more in-depth discussion of the Act, but there's some additional funding for WIC, which is Women, Infants, and Children. There's some additional funding for local food banks and for senior nutrition programs, and some allowances for states to provide money to families via SNAP to offset school lunch, losing the school lunches in their program. And you can go to the next slide, I think is the website for DHR. That's the DHR website. You can apply online. Like I said, the supervisor this morning indicated that they are still open and still, doing work, but they do ask that people apply online if they can. And if they can't, to just drop in the application in their box and they will call them back.
I will take 1 second to say, I've had several questions about the sound. For those of you who don't know, with all the people working at home, internet speeds have been, there's been some trouble with that. So I've had 3 or 4 people over the course of the time lose sound, and all of them reported it came back within 20 or 30 seconds. So if you lose sound, just be patient. It'll probably just if it doesn't come back in a minute or 2, let us know. But so far, everybody it said it cut out, it comes back. So just wanted to save you all the trouble of sending that to me.
We want to talk really briefly about ERISA, which is the Employee Retirement Income Security Act. Generally speaking, it covers employee benefits, and it's going to apply to group policies that you get through your employer. So if you have an individual Blue Cross, for example, policy, ERISA does not trigger. But if you have a group policy provided by your employer, then it is. It's important to note that as people are going to the doctor and having a little more medical things happening right now, if you have a claim for benefits that is denied by your insurance company and you have a group policy through your employer, then you cannot immediately just go straight to filing a lawsuit. You have to exhaust all your appeals options set forth in the individual policy that you have. It's important to remember that after you have exhausted all of your administrative and appeals remedies as set forth in your contract, then you're getting ready to go file your lawsuit. You are prohibited from bringing any additional evidence once you file a lawsuit. So make sure that you are documenting the record at the appeals and administrative level with any evidence that you could potentially need. You got to have it in the file if you want to be able to present it as evidence in the future court case.
There's been news this week that the Alabama Department of Labor has new guidelines for COVID-19 and for people filing unemployment. This is definitely welcome news. I know I've had clients and also family members excited that they may be able to have some options right now. But I wanted to talk about how unemployment has worked prior to the new guidance, and then briefly about what is going on with the new new guidelines. And so for unemployment compensation, there's 2 prongs. The Department of Labor will look backwards to see where you did work, how long you worked, and why you were separated from your job, and then we'll look currently to see if you're able to work. We put a link to the press release from the Department of Labor, but a lot of the loosening of the guidelines have to do with that second prong, your current ability to work. if people are being laid off or told to isolate, they may not be able to work right now, but they would still be able to file for unemployment now, where in the prior, rules and regulations, they would not be, but now they can apply for unemployment even if they're not able to work because they're being quarantined. You can go to the next slide.
One person did ask, could you quickly provide a brief insight into independent contractor versus employees for unemployment compensation?
So my understanding is that independent contractors would not be eligible for unemployment. I was on a conference call with Secretary Fitzgerald of the Department of Labor listening in, and someone had asked something, and I'm not sure, like if these new regulations would allow someone to apply if they were an independent contractor. Someone could try on Monday is when they're opening that up and see. Traditionally they would look back, the Department of Labor would look back to see if you were working under a covered employer. Like I said, so traditionally you wouldn't be able to apply for unemployment as an independent contractor, but I would hope that there would be some relief. I just don't know. And in looking back, the Department of Labor is also looking back to see if you paid enough into the system. It's kind of a complicated formula that they look at over your last base period is what they call it, to see if you've worked 2 quarters in your last base period or had enough wages in those quarters to be paid enough into the system, and that will determine how much benefits you qualify for. The minimum is $45 a week and the maximum is $275 a week. And also looking back, they're looking back as to why you were separated from your job, whether or not you voluntarily quit or were separated through no fault of your own. Typically, if you were fired for misconduct, you may be disqualified or you may have a delay in benefits depending on what that reason was for being fired. In Alabama, last June in 2019, reduced the amount of weeks that you could be eligible for benefits from 26 down to 14. You could ask for an additional 5 weeks under some circumstances. I have heard of people talking about maybe looking at raising that back up to 26, but we don't know right now. And then the second prong for unemployment is available to work. Typically, you have to be certifying to the Department of Labor every week that you're looking for work and able to work. And typically, if you were sick or something like that, you wouldn't be eligible for unemployment. This has loosened up. You can go to the next slide. I think it has the list of what the press release indicated would be workers who could file a claim. And it says workers can file a claim if they were quarantined by medical professional government agency, laid off or sent home without pay, diagnosed with COVID-19, or caring for an immediate family member diagnosed with COVID-19. Traditionally, there is a week that you would have to wait before your benefits would start, and the guidance is that that week is going to be waived, and they're saying you can start filing those claims Monday. And I had someone ask me who was laid off this week if they could go on and file today, and what I told them I wasn't sure is if they filed today, if they would still have that week that they would have to wait versus filing on Monday, because it seems like the week is going to be waived under this new guidance would start Monday. But again, I don't know for sure on that. You can file the claim online. There's a website you can go to file, or you can call. They're asking people to use the website first before calling. And just a note, if you're being paid to work from home or receiving sick or vacation leave, you're not eligible for these new claims. And I did want to say just quickly, if you're doing an appeal, or if you're denied claims, there is an appeal process, and that first layer of appeals is a telephone hearing. And then the second level of appeal is to the Board of Appeals. And I don't know at this time if you go through the process and have a telephone hearing, what would happen after that. It's one thing that's just kind of up in the air that we're waiting to see how things is going to move. It is important to note on the appeals that the appeal is considered complete upon receipt, not upon mailing. So if you are working with someone to do an appeal, keep that in mind, that it's considered complete upon receipt by the Department of Labor. So you need to make sure that those are documented, that it's in time.
I want to go back to someone has asked, and I held it for the end because I'm getting more and more questions as we go along. To clarify, can you repeat what the 50% requirement for schools to participate in the USD waiver of the requirement for a school food program? So that's for Lori.
So the waiver is from the U.S. Department of Agriculture, and it allows schools to continue serving lunches to students in schools where more than 50% of students were deemed economically disadvantaged. My belief is that they're using those that qualify for free or reduced school lunch to determine that number. And then the other was the memo sent out by Superintendent Mackey. Schools can serve meals if they utilize the Summer Food Service Program, SFSP, or the Seamless Summer Option, SSO. And they do, again, have an expedited application process offered to the schools that are not already enrolled. And what that is that many schools across the state continue providing lunches for students throughout the summer. And they're basically ramping up those summer programs early at this point.
You go to the next slide now?
Yeah. We wanted to highlight domestic violence. Some of the things that we can't have an in-person hearing for now are protection orders and elder abuse orders. And there have been reports and people talking about how one of the unintended consequences of social distancing and measures and isolation could be an increase in domestic violence. DV is not just physical violence, but when one partner is trying to exert control and power over another, and it typically would escalate into physical violence. But it's not only limited to physical violence. The National Domestic Violence Hotline has reported a growing number of callers talking about reporting that their abuser is using COVID-19 as a means of isolating them further. And I saw reports of, in China, the number of domestic violence calls in February 2020 was 3 times more than February 2019. And, you know, there's concern that people could be afraid to go to the doctor or go to somewhere of fear of catching COVID-19. A lot of times people who are victims of domestic violence, you know, use the time where they're leaving the house to go to work or something like that as a way to kind of get away. And if people are being quarantined, it could be there could be risks for them. We have the number to the Alabama Domestic Violence Hotline and the Coalition of Domestic Violence. And if there's someone who is seeking relief or seeking a way to get away from an abuser during this time, protection orders can still be filed right now. And I think you can go to the next slide. The code section that applies for protection orders is listed. It's a fairly straightforward way to apply for relief. There is a form that Office of Courts has put out that people can use, and I would recommend using that form because judges are familiar with how it is and it's uniform across the state. You can add additional narrative, you can attach it to the form, but it's important to use. And you can ask for ex parte relief, and some of the ex parte relief you can ask would be to enjoin the defendant from contacting, committing acts of abuse, and you can even remove the defendant from the residence regardless of ownership with an ex parte PFA if their preponderance of the evidence shows that there is a need for it. I always advise clients that it's a piece of paper. It helps you coordinate with the police and helps you with getting police involvement if needed, but it is a piece of paper and it cannot protect against a fist or a bullet. So don't want to end the conference webinar on such a heavy topic, but it is important to realize that some of these isolation measures are going to be have a heavier impact on some who are facing violence.
And I think it's important to note too, that much like claims of exemption, most PFAs are filed by pro se litigants. If the courthouse is closed, even though judges would still hear those hearings, they're not able to file their PFA complaints. So although we are telling you like, oh yeah, you can still file those PFAs and you can still, judges are going to have hearings on those. That is one of the exceptions. That's only true if an attorney's filing it or if the courthouse is open or accepting filings. Otherwise, the only way that somebody can seek help is through mailing their complaint, and who knows when that's going to be addressed. So again, you can expect to see an increase in the number of calls for people that need a protection order.
Okay, and before we move on, had a series of questions. For federally held student loans and repayment, how does one actually take advantage of the 60-day moratorium? Do you know?
This mandate came out about 10 minutes before this webinar started, so I don't know. I don't know that there will be any steps to follow because it seems like from the press conference, it's going to be automatic, but the best I can tell you is to continue looking for further guidance on that. And again, like, you know, we will have a future webinar on that topic, but so much is changing. And as we saw with the HUD mandate, what was said at the press conference and what the order actually said were not the same. So I think it's going to be important to watch and see what actually comes down from the Department of Education. But again, like that was 10 minutes before we went live here.
Okay, real fast, we do have some social workers watching from the Department of Public Health. One of them did want to point out, in addition to what you said about food stamps, that elders have a simplified food stamp. If seniors want food stamps in a simplified form, and there are different, there are easier ways for them to get benefits.
That's an excellent point. And also, I think you're going to have a lot of people that are not current STAP recipients that now are going to need to be. So it is important to encourage people to apply if they have that need.
And a question, students who are laid off due to college closures who are part-time work-study jobs, are they going to qualify? I think the answer is if they've worked enough covered work. Is that right?
Right. As far as I know, if the employer was covered, and I don't know. I'm not sure.
Yeah. I mean, if it's a university, I would guess they would be. Well, now they're really coming. Well, I'll go ahead and let you go to your last slide and follow you up with the questions that are all coming in.
Okay. In the interest of time, we're not going to talk about these. In fact, I'm not even going to briefly mention McKinney-Vento because I think that's months down the road. But I do want to say real quick that people are panicking, people are freaking out, and I'm not by any means encouraging you to add to the panic by calling everybody on your client list and saying, hey, you might die and you need a will. But I do think it is an important time to remind people that it's good to have a will. And if you're going to do one, you absolutely need to have a power of attorney and an advanced healthcare directive prepared with it.
I will note that at least one attorney, Mr. Greenberg, says that colleges usually are not covered employers for work-study programs. So probably have to look into that. One person went back to the unemployment, the things we were talking about, and asked, do employers have to participate at the during hearings? And what if they just submit things in writing?
Employers contested it at all. So I've had appeals where the employer didn't show up, you know, decided it wasn't worth it. So it's up to the employer if they want to, how much they want.
I would note that I have had unemployment cases where the employer did not show up, did submit things in writing, and then actually did win the appeal. So, I mean, they can, but it is, of course, a risk that they take.
Well, I think the specific question was, can they just write a written statement in lieu of appearance? And although I think most lawyers would find it pretty offensive, they certainly can, because the rules of evidence are waived in unemployment hearings. And the unemployment hearings, the present kindness of them changing the rules for COVID-19, folks suffering aside, has not been always very friendly to employees. So the answer is that the rules of evidence are waived, so you could probably take a written statement if they choose to. It's up to the hearing officer. And we are at 12:59. So if you want to, what are people being forced to go to work? Oh, do you have any advice for people who are being forced to go to work when they feel unsafe or their health is at risk? And by the way, as your boss, how do you feel about this today? Rochelle or Laura, do you have any ideas?
I mean, I guess I don't understand if the question is like under the new guidelines. And the answer to that is, I don't know. But that aside, I mean, it's an at-will state. So you run the risk of losing your job if you choose not to come to work. But as we go to more and more counties and states that are closing down and saying only essential services can remain open, and then you're seeing what is exactly an essential service. I think that question is going to become more and more prevalent, and I suspect we'll have further guidance on that a little down the road.
Yep. And I will note that the unemployment compensation law specifically said it will not cover people who choose to not go to work because of COVID-19. It has to be the employer's decision. They will not pay for employees who choose not to go because they don't feel safe. So that much is clear. All right. With that being said, thank you, Lori. Thank you, Rochelle. You have the information here if you want to contact them or me here at Legal Services. We are at 1 o'clock. We did want to highlight next week's webinar, but before I give it back to Lori to do that, I've gotten a couple of questions here at the end. If you have attended the majority of the webinar, if you signed up and registered, you will get credit automatically. I will send all of this to the State Bar along with your name and your bar number, so it should just appear in your bar credits as soon as, I don't know again what the bar schedule is. If they're closing down, your credit will be there automatically though. So that should all be taken care of, nothing for you to do.
Okay, next week, same time, 12 o'clock, we'll be having a webinar on Families First Coronavirus Response Act. The presenter is going to be Davey Knupp, and he's mostly going to be talking about employment-related issues through the Family First Act. And he's going to talk about some tangential employment issues such as FMLA and the Americans with Disabilities Act as they relate to employment situations. So we hope you'll join us then.
Thank you all very much.